Welch, W-E-L-C-H.
You may proceed, Mr. George.
Thank you very much, Your Honor. Good afternoon, ma'am.
Good afternoon.
Ms. Welch, you are a CSI investigator for the Orange County Sheriff's Office?
Yes, that's correct.
All right. Ma'am, I want to draw your attention to August 13th of 2009. On that date, did you come in contact with the defendant, Caylee Anthony?
Yes, I did.
And why did you come into contact with her on that date?
I came into contact with her to photograph a tattoo that was on her back.
Previous motions and objections.
Noted in previous motion and noted in previous objections. The court will stand by prior rulings. Objection will be overruled. Thank you, Mr. Baez.
In total, how many photographs did you take?
I took a total of 23 photographs in this instance.
They weren't all of the, were they all of the tattoo?
No, they were not.
All right. Let's go first to, I'm showing you what's been previously marked for identification Q. Oh, I would, Judge. That would probably help a little bit. Can you see that, ma'am?
Yes, I can.
All right. Do you I'm sorry. QU? Do you recognize QU?
Yes, I do.
Can you, what is that? Did you take that photograph?
Yes, I did.
Is that a fair and accurate representation of the photograph you took of the defendant on August 13th of 2009?
Yes, it is.
And cite no predicate.
Overruled.
Let's go to HJ. Okay, I'm now showing you what's been previously marked for identification HJ. Do you recognize that photograph?
Yes, I do.
Did you take that photograph?
Yes, I did.
Is that a fair and accurate representation of the defendant and the tattoo as you saw it on August 13th of 2009?
Yes, it is.
Thank you very much. I don't have any further questions of this witness at this time.
Cross-examination.
No questions.
Okay. May the witness be excused.
Yes, sir.
Thank you, ma'am. You may be excused.
Thank you.
Bobby Williams, BOBBYWILLIAMS.
You may proceed, Mr. George.
Thank you very much, Your Honor. Good afternoon.
Good afternoon.
Mr. Williams, how are you employed?
I'm currently employed at Cast Iron Tattoos.
And what do you do for Cast Iron Tattoos?
I'm a tattoo artist and manager.
How long have you been a tattoo artist?
As of June 5th, 2011, I've been there 8 years.
That kind of answers my next question.
Oh.
Were you working at Cast Iron Tattoos back in July of 2008?
Yes, sir.
Do you know Caylee Anthony?
Yes, sir.
How long have you known her?
Roughly, say about 7 years.
Okay. Sir, directing your attention to July 2nd of 2008, did you see the defendant on that day?
Yes, sir.
This time renewing our previous motions and objections.
Objection overruled. Noted in previous objections. You may continue.
Thank you, sir. Where did you see her?
At the shop.
All right. Why did you see her at the shop?
She came in to get tattooed. She had an appointment.
Okay. Do you know when she made that appointment?
It was probably 3 to 4 days prior.
Did she make that appointment with you?
Yes,
Was that appointment in person or over the phone?
over the phone.
Did you recognize her voice?
Yes,
Did she identify herself?
yes.
When you spoke with her a couple of days before and she made the appointment, did you ask her what she wanted done?
Yes, sir.
What did she tell you?
Bella Vita and a feminine type font.
In a feminine type font?
Feminine.
Okay, thank you. Now, is that a routine question that you would ask, what a customer wants done?
Usually.
Okay, why?
Just to get an idea of what they want and just to give me time to get stuff drawn up and make any changes before they actually come in.
So did the defendant make her appointment?
Yes, sir.
Now, when she arrived, did you already have the design ready to go?
No, I ended up actually drawing it that day.
You drew the design?
Yes.
All right. And did you apply the tattoo?
Yes, sir.
How long did the tattoo take to apply?
With drawing time, roughly probably about 30 minutes or so.
Okay, let's bring up Welch. Sir, I'm showing you what's been previously marked for identification HJ. Do you recognize that?
Yes, sir.
What is that?
Bella Vita.
Okay. Is that the tattoo that you drew on the defendant on July 2nd of 2008?
Yes, sir.
Is that a fair and accurate picture of what you did?
Yes, sir.
All right, Your Honor, at this time, the state would move what's been previously marked for identification HJ into evidence.
We would renew all previous motions and objections.
Approach the sidebar. Okay, state recognized presence of jury.
Yes, sir.
The defense,
Yes, sir, we do.
Mr. George, you may continue.
Thank you, Judge. I guess when we left, the state was moving what's been previously marked for identification HJ into evidence.
Same objections?
Yes, sir. We renew all previous motions and objections.
Noted in previous motions, noted in previous objections. It will be received in evidence as states numbered.
Thank you, Your Honor. At this time, I would like to publish
You may.
321. Okay. All right, sir. You drew out this this design before the tattoo was actually applied, correct?
Yes, sir.
The star-like figures, was that something that you designed?
Yes.
Before applying the tattoo, did the defendant basically sign off on it or agree to it?
Yes, she did agree to it.
Okay. Your Honor, at this time, may I unpublish it?
You may.
All right. You said that this tattoo took about a half hour to apply. Is that correct?
Yes, sir.
When Ms. Anthony first came to your shop, how would you describe her demeanor? How was she acting?
Normal.
Relevance,
Overruled.
403.
And previous motions and objections as to this topic, Judge.
Overruled.
You may answer the questions.
Normal.
What does that mean?
Didn't seem upset about anything.
Did she seem happy?
Yeah, but I guess pretty happy for the most part.
Okay. While you were applying the tattoo, did you have any conversations with her?
Not other than asking her if she was doing okay during the process of it.
Okay. Did she indicate that she was doing okay?
Yes, she was fine.
All right. What was she doing while you were applying the tattoo?
She was on the phone.
Okay. Was that the majority of the time?
Yes, sir.
All right. After the tattoo was applied, did she, I'm sorry, how much does a tattoo like that cost?
That one was 65.
All right. Did she,
Overruled.
how did she pay you?
Cash.
Okay. Did she immediately leave the store at that point?
No, sir.
What happened?
Co-worker and I, we ended up ordering pizza, and she actually had a couple slices,
Okay.
and then
Who paid for lunch?
she did.
All right. Directing your attention to July 15th, did you have the occasion to see the defendant again?
Yes, sir.
Where did you see her?
Inside the shop.
Okay. When she came into the shop, why did she come in? Did she tell you?
She came in to set another appointment.
When did she make that appointment for?
I believe it was 19th. The 19th, so a Saturday.
When she came into the store, well, actually, let me go back a little bit. When she came to see you on the 2nd, did she come by herself?
Yes, sir.
When she came to see you on the 15th, did she come by herself?
Yes, sir.
When she came in on the 15th and made another appointment, how was her mood?
Same.
Relevance,
Overruled.
Motion and objections.
I'm sorry?
Same, just normal.
Okay. Normal meaning what?
Happy. Not seem to be upset or anything.
All right. And she made an appointment for 2 on the 19th?
Yes, sir.
Now, did she tell you what design that she wanted applied on the 19th?
No, not at the time.
What did she tell you about the design?
She just wanted it was an appointment for her and a friend that was coming out of town, and she didn't really describe a design that she wanted at the time.
Okay. Did she say what the possibilities were?
Chances are maybe I think it was either be a matching tattoo with the friend, or either they could have been getting like something completely different. So I guess she was just pretty undecisive about it.
Knowing her as long, were you aware that she had a daughter named Caylee?
Yes, sir.
Did she mention anything about Caylee when she visited you on July 2nd?
No, sir.
On July 15th, did she mention her daughter Caylee?
Yes.
What did she say about her?
She's with the nanny.
Okay. Did she say anything about bringing her daughter into the shop?
Yes, Caylee would be in the shop on the 19th when she came in for her appointment.
Okay. Thank you very much. I have no further questions of the witness.
Cross-examination.
Good afternoon, Mr. Williams.
Good afternoon.
Sir, is it customary in your business that people get tattoos to remember their loved ones that have passed?
They do, yes.
Okay. And that's something you do quite often?
Yes, sir.
Okay. And did you do the tattoo for George and Cindy Anthony that they've done, that they've had to commemorate Caylee Anthony?
No, sir.
Relevant, outside the scope.
Sustained.
Did you have any other interactions for tattoos for any other members of the Anthony family?
Outside the scope, irrelevant.
Sustained.
I have no further questions.
Mr. George?
When she came in on the 2nd and got her tattoo, did she appear to be mournful?
Excuse me?
Was she mourning? Did she appear to be mournful?
Objection, Judge.
Your Honor, this is a direct.
We have a
Just a
motion.
second.
Objection, and we have a motion as well.
Approach the sidewalk. Okay, Mr. George.
Thank you, Judge. I have no further questions of the witness.
May the witness be excused.
Yes, sir.
Thank you, sir. You may be excused. Okay, ladies and gentlemen of the jury, this concludes the presentation of evidence for today. And I will see you in the morning at 9 a.m. Okay.
Wants to renew a motion for mistrial on several grounds. One, to renew the one we made the other day regarding the morphing of the photograph of the tape and the skeleton and so forth. Additionally, now, today, we have issues regarding the heart-shaped sticker that did not match anything whatsoever that was described by FBI Agent Fontaine as being dime-shaped. We've objected that. We did pretrial motions on that, and it caused speculation. And then, of course, the last thing, the prosecution trying to introduce the issue of remorse. You did, of course, sustain the objection, but the jury heard the question. So on those basis, and indeed reminding you again of the motion, the consciousness of guilt argument, for what it is worth to you on that, the Florida Supreme Court ruled in Mena versus State that the behavior has to be susceptible of no prima facie explanation except consciousness of guilt. The state has not met that burden, and with respect to that, the post behavior of this defendant, the Mena court says it should not be admissible, and we're asking for a mistrial on that basis. Thank you very much.
Reply from the state of Florida.
Your Honor, as to the the superimposition video. There's no new arguments presented, so I'll make no new response. As to the tattoo, at this point, the only evidence presented before this court as to the defendant's version of these events is that her daughter was alive and absent from her custody against her will. The fact of her obtaining a tattoo that says something which the court may eventually take judicial notice means the good life or the beautiful life is certainly inconsistent with the stated defense. Obviously, counsel's opening statement presenting an alternative version is not in evidence before the jury yet. The only version of the defendants we have so far is the various versions of the Zanny story, so I would submit that that is relevant. As to the question asked by counsel that was not answered, the defense asked the question, quote, is it customary in your business that people get tattoos to remember the loved ones that have passed? Clearly, we would submit that it was an appropriate question of the court to sustain the objection to ask about whether the demeanor of the person requesting the tattoo was consistent with someone asking for a tattoo because loved ones had passed. We don't believe that that was a question that went to the remorse issue. It was a question that went to a response to the defendant's question. The court sustained the objection. It wasn't answered. And I would submit that there's no grounds for mistrial in this case as to any of these grounds.
Motion for mistrial will be denied. Okay, I guess the only housekeeping matters we need to take up is the state is making a request for the court to take judicial notice. My suggestion is that the dictionary that you're going to use, that you get a copy of that page, cover, sheet, etc., to the defense so they can have an opportunity to examine it tonight. It would not hurt if you got me a copy of that also. We will do that if the court takes judicial notice. Then the court will give the meaning of that phrase. Then I take it at that point the state of Florida will rest.
Yes, Your Honor. There are two items that have been marked for identification and identified, State's Exhibit IP and IQ, which we will be formally moving into evidence. These are two of the canned samples of the spare tire cover. They've been fully identified. I just realized we haven't actually formally moved them in, so we would be doing that. And aside from that, I believe we would be resting.
Okay. As we discussed earlier, I believe at sidebar, despite the efforts of the defense, they were originally told to be prepared on Thursday. They tried to move some witnesses up to Wednesday, but they could not do that. So then we will start out on Thursday with the defense's presentation. And I take it that after the state rests that the defense will be prepared to make its motion for a judgment of acquittal. Okay.
One suggestion I would make to lessen the inconvenience to the jury, we will commit to the court that the only things that we have left to do are the judicial notice and put those two cans into evidence. So we would suggest for the jury's comfort that we do the JOA argument tomorrow with the assumption that all the evidence is as we have seen. And then when we come in on Thursday, we will very quickly do those last bits, rest, and the defense can begin their case. If the court wants to bring them in for those couple of minutes in the morning, we can do that. But I thought for their convenience, it would be better to do it that other way.
Mr. Mason?
Prosecution needs to rest or not rest. I'm not going to make an argument until they rest.
We'll bring them in tomorrow then.
Okay. as I previously stated, they will, as I told them, they will be here in the morning. Now, this is food for thought for the defense. Since we will be working on Saturday, do you want to work any extended hours on Saturday? Or do you want to stop at 1 o'clock? Choice is up to you.
I'm hearing from my elders that 1 p.m. is the max.
I just asked for
I understand we may have witnesses from out of town that we might want to go a little bit beyond that, but for scheduling purposes, I would like to stick to the 1 o'clock schedule.
That's fine. The only reason I asked is if you go beyond that, I have to make arrangements to feed them here.
I promise to let the court know as soon as I know if that's going to be an issue.
Yeah, because I have to make those arrangements because they are not fed here on Saturdays. That's why I was asking the question.
Yes, sir.
The other thing I wanted to address is, since we are going to come back tomorrow, the defense has indicated they are not calling any witnesses till Thursday. Is that correct? Can we take them at their word on that, as opposed to having some surprise tomorrow when we only bring the information for the argument for the judgment of acquittal?
I think I need to answer that.
Yes, yes, they do.
Well, I think I made the announcement that the state will put on whatever they need to put on tomorrow, that you will rest, and that we will hear the motion for the directed verdict, and then the defense will make their presentation on Thursday. I thought that was what I said. I don't know what I'm going to do, Mr. Mason.
Counsel has cases that he is planning to rely on, that he provide those to us this evening, since we've provided ours to him 2 days ago.
Mason, since he will be addressing me.
First thing in the morning. Now that you've finished your stuff, I'll work tonight and I'll get it to you in the morning.
The law is the law, folks. I mean, the law on circumstantial evidence is the law. I mean, there's no great mystery. The cases that the state cited in their book are contained in the case that Mr. Mason is familiar with, that I mentioned to the two of you, Serrano, and the facts are the facts, which both sides are well aware of what the facts are. So we will see. Anything else? Now, so we won't get one last thing. The grief expert, have y'all arranged depositions for that?
I believe it's set for Saturday afternoon, as I recall.
Okay. I think I have given y'all two cases. There's another case. Let me see, can I find it? Another case for your consideration that I found was the following case. Durband, D-O-R-B-A-N-D, versus State, 12, Southern Edition, 3rd, 255, a 2009 decision of the First District Court of Appeals. While it does not exactly deal with the issue of grief, it has some application to this particular case, since it talks about issues. In that particular case, the state placed heavy emphasis upon the defendant's calm demeanor following a traumatic shooting. And the defense wanted to offer evidence to explain that. So you may want to read that for your edification. Okay, anything else, folks? From the state?
No, sir.
We'll be in recess to 9 a.m. tomorrow morning.